What did the judge say about XRP? Which emails is the judge talking about? Is the lawsuit over? To learn about it, continue to watch this video to find out more. Welcome viewers to Pianta Crypto. Here we bring you the latest updates on cryptocurrencies. Please hit the subscription button, like my video and turn on notifications so you don't miss our next update. The SEC documented the lawsuit in the US against Ripple on December 2, 2020, alleging that its offers and sales of XRP disregarded the registration requirements of Sections 5 and NC of the Securities. Ripple claimed that the SEC didn't provide a specific warning that its offering and selling XRP implicated federal securities laws, depriving it of fair notice according to a memorandum of law supporting the SEC's motion to strike Ripple's defense. The SEC stated in the notice that in 2012, before it sold a single XRP, Ripple's lawyers let Ripple know that the sale of XRP could be considered a sale of securities under the federal securities laws. It added that from 2013 through 2020 Ripple sold XRP for nearly $1.4000000, and almost each of its revenues came from the sales of XRP, to public and private investors. Given the historical advice Ripple had received since 2012, questions for market participants on the obvious question of whether Ripple's offers and sales of XRP required registration under the securities laws and the SEC's formal investigation. Defendants were aware for many years that the securities laws could apply. The SEC must surrender to Ripple an email with a draft of former Director William Hinman's speech on whether either is security as part of an ongoing lawsuit the regulatory agency documented against the crypto startup, a judge ruled Thursday. The SEC sued Ripple and members of its leadership toward the end of 2020 on charges the company sold and continues to sell the XRP cryptocurrency in violation of federal securities law. The agency and Ripple have been involved in a protracted back and forth over what sort of documents must be made accessible through the discovery process. Ripple sought several documents detailing internal SEC communications and policies. SEC attorneys claim these documents contain Stafford deliberations and are protected against discovery. Magistrate Judge Sarah Nat Berman of the Southern District of New York Federal Court ruled some of these documents are protected, however ordered the regulator to turn over others, including the email with Hinman's speech and some notes from meetings between SEC staffers, third parties that are not Ripple. We're pleased with the court's order which grants Ripple access to important documents that the SEC was withholding. We will continue to defend this case aggressively and we remain optimistic that resolution of this case will provide much needed clarity to the industry, Ripple General Counsel to Alter said. An email of the draft of a 2018 speech by him and former Director of Corporation Finance is included in the list of documents to be surrendered. Hinman gave the speech in June 2018, telling the audience at a conference that in his view Ether was not a security. The speech was seen as urgent for the crypto industry given the first 60 million Ether was sold to raise funds for the Ethereum Foundation. Ether is now commonly seen as a commodity in the US, with the Commodity Futures Trading Commission overseeing derivatives products based on the cryptocurrency. Hinman's speech reflected his views, he said at the time appointed judge referenced on Thursday in her ruling. The privilege does not protect the personal views of agency employees unless they bear on the formulation or exercise a policy-oriented judgment. The judge said in a 23-page ruling. Accordingly, emails concerning the speech or draft versions are neither pre-decisional nor deliberative agency documents entitled to protection. While the email with the draft speech must be turned over, a separate email sent by the Office of the Chief Counsel for Corporation Finance the day preceding his speech does not need to be turned over, the judge wrote. The documents related to SEC staff's legitimate analysis of XRP contain the SEC's staff preliminary views during the Division of Enforcement's investigation into XRP and didn't present a recommendation to the SEC, she said. These documents were prepared for the investigation into XRP and therefore qualify as the kind of pre-decisional and deliberative legitimate analysis the deliberative process privilege protects. The SEC also does not need to turn over notes from meetings between SEC staffers and Ripple as well as inter-agency discussions, the judge ruled. Ripple has won a major procedural victory in its fight with the SEC, a federal judge ruled on Thursday. The judge has ruled that the agency cannot claim that emails related to a landmark 2018 speech about Ethereum are privileged documents. A former top SEC official delivered the speech in question, William Hinman. He let an audience know that Ethereum was not a security because it was sufficiently decentralized. That speech is also central to the lawsuit. The SEC alleges that Ripple and its top executives knew that the blockchain's advanced currency XRP was a security that must be registered with the agency, Yet it was sold to the public. As part of its lawful strategy, Ripple has sought to obtain evidence on how him and decided to fear him was not a security. This evidence could assist the company with refuting the SEC's claims about the nature of XRP. Thursday is a large batch of documents, for instance notes from SEC crypto expert Valerie Szczepanik are discussed. The notes contain various SEC deliberations. Also included are emails in which Human and others discussed a draft of the Ethereum speech. The SEC had argued that the documents fell under its so-called privilege. Privilege is a legitimate term that means that a party does not need to share it with its opponent in a lawsuit. The SEC invoked the attorney-client privilege and other privileges designed to shield government agencies in certain situations. U.S. Magistrate Judge Sarah Netburn agreed with the SEC on certain documents, however she rejected the agency's argument for more than a dozen batches of other documents, in the case of the emails about him and speech Netburn concluded that the privilege didn't make a difference because the speech was his personal views, not those of the agency. Here's the most important part of the decision. Hinman and the SEC concede agency employees discussed his speech, yet it just so happens this speech was only incidental to the actual policy making because of TIDE U312 F3D at 80. Thus there was no essential link in the SEC's either consultation process. Grand Centerpiece Ship 166 F3D at 482. As a result, emails about the speech or drafts don't have pre-decision agency documents. Not are there any deliberative documents that are entitled to protection. That Burns' decision will give Ripple new ammunition in its lawful opposition. The decision will also benefit public opinion. Here many think that the SEC has unfairly cracked down on the company in the crypto industry. Nevertheless, the ruling is only a procedural one. It has minimal bearing on the larger issue in the case. This issue revolves around whether XRP is a security or not. Overall, Ripple Sun access to 14 entries and 3 additional documents. The SEC is further ordered to review its privilege log and produce in full or in part any documents previously withheld based on the privilege that would be inconsistent with this order, Judge Annette Burke wrote. The case prone to be made in court in the SEC versus Ripple lawsuit is that SEC officials, namely ex-SEC Commissioner William Hinman, have given a decisive advantage over the theory. His 2018 speech stating that in the event that there is not a security has triggered a bullish move that position ETH as the second most significant crypto asset in aggregate market capitalization. Judge Netburn has recently given a blended ruling regarding the deliberative process privilege issue, as she declared some documents were not privileged yet kept others as it is. As part of that decision, the FCC was ordered to hand over the email regarding William Hinman's 2018 speech. The email was sent to 63 individuals. The judge also accepted the SEC's claim the speech was only Hinman's personal opinion and was not intended as policy. For years, Ripple's XRP was placed in number 2 after Bitcoin and has steadily lost its standing since then, with other computerized assets taking their place in the ranking. Despite this, Ripple Labs continues to work with payments